So I think we can get started now. So welcome again to today's webinar on the first experiences in case law under the new rules of procedure of the EPO Boards of Appeal. I'm here with my colleague and partner of the firm, Arwed Burrichter. We are both from the chemistry and life sciences team here at Course and Florac, and both also have a very busy opposition and appeal practice. So we ourselves could already gain some experiences with the new rules of procedure, which, as you know, have entered into force January 1st, 2020. So now almost 12 months under the new rules of procedure. And of course, in preparation of this webinar, we've also done some review of the case law that has evolved since. Maybe some housekeeping matters to begin with. This is a webinar hosted via the Zoom platform. There are several tools with which you can interact with us. Right now, you're all still muted and we cannot see your videos. At the end of the webinar, we will open up a discussion, and whoever of you wants to join us for this discussion, you can raise your hand. There's a raise your hand function that you have via Zoom, and then we will promote you to discussion participants so that we can also see and hear you then in the discussion section. If you have questions during the webinar, please enter those into the Q&A tool that you see in your webinar control panels. You can also use the chat, but we would prefer if you enter the questions into the Q&A function because it's easier for us to deal with them in the correct order. Other than that, I would like to alert you also to the fact that this webinar is being recorded. We will not record the discussion part at the end, but the main part is recorded. And of course, you will also receive not only a link to the recording afterwards, but also a set of our slide deck. Yes, and I think with that, we can start the webinar. So thank you all for dialing in. At this busy pre-Christmas period, we're happy to conclude this year of webinars with this final one. Maybe before we start, just to let you know that today is a webinar on the case law under the new rules of procedure. We had a webinar earlier this year where we went in depth through the actual changes that the new rules of procedure entail. And this webinar has also been recorded. So if you feel during this webinar that you would like to hear a bit more about the basic or what actually has changed, please feel free to visit our blog on our website and see the recording of this webinar. And Christiane will also post into the chat a link to the current versions of the rule of procedure. So if you have two monitors or a split screen, it might be helpful for you to actually have a look at the wording of the rules of procedure while we talk about certain provisions and how the case law has dealt with them. And another thing up front, the decisions we will present today are exclusively on procedural matters. So I hope they are not too dry for you, but as you've registered for this webinar on the new rules of procedure, I guess you're particularly interested in procedural issues. If you're also interested in more substantive issues, substantive case law, I would also recommend that you watch the recording if you haven't seen it live of our webinar in November dealing with substantive case law developments at the EPO in 2020. Yes, with that, I think we can then dive into the actual session. So our agenda today is more or less going through examples of decisions that we identified and think might be of interest to users of the system. And by the way, to get a better feeling of how experienced you actually are so that we can gauge a bit our introduction, I would like to start a brief survey where you could maybe indicate your level of experience. So how familiar are you with EPO appeal proceedings? Please click not at all. It's an anonymous survey, so please feel free to answer directly. Yes, I see a lot of answers coming in. Please click your answer. Just waiting a couple of seconds more. We have 75% participation already. There's still some answers coming in, but I think we can conclude the survey. Yes, and you can see now the results of the survey. So it's quite a mixed audience that we have today. So there are a couple of participants which actually are not very familiar with the rules of procedure. And there's a majority, or around 50% of you have observed only a few cases, but are not really actively involved in the cases. So that's really good for us to know, so that we can give you a little bit of background also underway. Okay, so our talk will be divided into different sections, and Arwed will introduce the gist of the changes to the rules of procedure in a moment. But in principle, there are more case management aspects and more aspects on late filing and admissibility. And that's why the cases that we will discuss will deal with this admissibility part. So is it possible to get new arguments, requests, and so forth filed fresh in the appeal proceedings? That will take a large part of today's webinar. And then two more specific issues like the decision in abridged form, which are now possible, and also the question whether how the remittal practice changed. And if we have time, we would like to talk to you a little bit about a very, very recent development, namely that of video proceedings. Now, in light of the COVID-19 pandemic, the EPO and also the Boards of Appeal have reacted and have offered video proceedings. And then now is a new Rule 15A, Article 15A proposed for the rules of procedure, which will govern those video proceedings. Yes, and with that, I think, Arwed, the floor is yours to say a little bit about what actually changed in the new rules of procedure.
And quite a bit has changed. Let's wrap this up really quickly, especially for those of you who are not so familiar with the new rules of procedure yet. Now, the new rules entered into force on January 1st, 2020. They apply to all pending and new appeal cases. There are very limited transitional provisions. So most of these new rules apply to pending cases, also to old cases. Why one important thing to know is that it does make quite a difference whether you received a summons before or after January 1st, 2020. But we're going to talk about this in detail later. Now, the clear intention, objectives of the new rules are to increase the efficiency and the predictability of appeal proceedings. It was often criticized that these appeal proceedings take too long and that the boards decide very differently on cases. And the clear objective is to increase efficiency and predictability. Now, there are two main implementations with the new rules. The first is that with the new rules, a new case management system is introduced within the boards of appeal. Now, and this new management system gives the boards much more flexibility in how they handle the cases. The hope here is that the overall length of appeal proceedings will decrease dramatically. The goal here is 2 years. So 2 years from the filing of the notice of appeal is the goal of the new system. Now, the new rules also include provisions that specify what is admitted at which stage of the proceedings. There are 3 levels of convergence, and these impose increasingly strict restraints on introducing new matter on appeal. Now, we're going to get to this later in detail, and we're going to present to you some case law that shows how the boards handle these 3 levels of convergence in practice. Now, as you see here on the right, the new rules have an impact not only on the boards, on how the boards and the parties of the appeal proceedings, but they actually also have quite an impact on the first instance proceedings and also the enlarged board. Now, one of the consequences for the first instance proceedings is that as a party, you really need to make sure that you bring all important facts, arguments, and auxiliary requests already at first instance. If you don't do this, you risk that they will be no longer admitted into the appeal proceedings. And we see this already. The first instance proceedings are becoming much more front-loaded. The length of the submissions in first instance opposition proceedings and the number of precautionary auxiliary requests is increasing, and this makes sense because the whole purpose of the new rules of procedure is to make sure that the appeal is a judicial review of the first instance proceeding. The purpose is not to introduce new arguments that are being examined then for the first time. Now, let's take a quick look at the new case management system under the new rules. Really, there are 5 elements here to the new case management system. The first change, and most of you will have heard about this, is that at the end of each year, the boards publish a list of cases that can be expected to be heard or decided in the following year. This is regulated in Article 1(2), and so these are cases, the cases on the list are cases where you are likely to receive a summons anytime soon. Now, the summons is important because it triggers the 3rd level of convergence for late submissions. So it's a good idea to keep an eye on this list. If your case is on that list, you pretty much should get down immediately and review the case and check if you need to make any further submissions to get the benefit of the 2nd level of convergence and not get into the much more difficult 3rd level of convergence. Now, one thing is important to know. This list is non-binding. So, I mean, it's good to have, but don't rely on it too much. We recently had a case where we received a summons for 2021 in a case where the case was not on that list. So really, the list has a non-binding nature. It's good to have, but by no means rely on the list. Now, the second change in case management is that the boards can now more easily consolidate and accelerate cases. Now, this is regulated in Article 10, and this is particularly important for interrelated cases, for example, co-pending oppositions in a parent and in a divisional application. And if you have interrelated cases, you can consider making the board aware of this, and such cases will then be typically heard one immediately after the other. This can be of great advantage to the proceedings, so it's really worthwhile checking your list of cases whether it makes sense to consolidate cases here. The boards try to do this on their own, but nevertheless, of course, they cannot see all things, and it's really up to the parties also to make them aware of this. The new Article 10 also sets out the rules for an acceleration of appeal proceedings. Now, acceleration can be done upon request by a party, by a court, or also ex officio. Now, not really much has changed there compared to earlier days. The typical case where you get immediately an acceleration is the case where you have a co-pending infringement proceeding. But we have recently seen accelerations also on other grounds, for example, where you have very old cases that are pending already for a long time, or also in pharmaceutical cases where generic entry is coming close. These are cases where, if you reason this well, you can get an acceleration. And it seems to us that the boards are more receptive to this under the new regulations compared to the old regulations. Now, then turning to the summons to oral proceedings. Now, this is actually an important change here. This is regulated in Article 15.1. Now, the summons, as I said earlier, is really important because it triggers the third level of convergence for late submissions. Now, after the summons, it is very hard to get anything further admitted into the proceedings. So it's important to keep an eye on that date. Now, Article 15.1 requires that the summons is given at least 4 months before oral proceedings, and not earlier than 2 months after receipt of the written reply to the grounds of appeal. So for all practical matters, this means that it's a good idea to immediately review the reply and to check if anything else needs to be rebutted before you risk getting the summons, right? So you for sure have 2 months after you receive the reply of your counterparty before you risk receiving the summons. And this really is the time for final review of your case to make sure that you have everything on file that needs to be on file. Now, Article 15.1 also requires the board to issue a preliminary opinion before oral proceedings. Now, this was done in the past quite often for most boards already. Some boards did not do that. Now all boards do this. The extent of the preliminary opinion varies, but at least all preliminary opinions address the main issues. They do not really give a concrete opinion in all cases. We see differences between the boards here, but at least you now get an indication of what issues will be important and the preliminary opinion of the board. Now, the Article 15.1 also says that wherever possible, the preliminary opinion shall be issued 4 months in advance of oral proceedings. Now, in practice, this does not quite work. Now, very often in our experience, we get the opinions much later, not at the same time with the summons, but maybe 2 months before the oral proceedings, sometimes even 6 weeks or 5 weeks before oral proceedings. So this 2 month, the 4 month in Article 15.1, which are desirable, this doesn't quite work yet.
And I think that the other two topics here, the referral and the decision in the bridged form, we will also have specific case law on that, and I think we can go into that once we reach that section of the webinar. So that's the new case management system, right? The second big part of the changes, and which will be also our major focus today, is what Arwed already referred to these 3 levels of convergence, and this governs what is still admitted into the appeal proceedings. And we will guide you through this using this diagram here, which in the view of the boards shows the ideal scenario where you have a certain scope in the first instance, and then if you go down here time-wise, the scope is always more and more reduced to what the board thinks is kind of the pertinent subject matter, or the points at dispute or that are crucial to the decision. And in principle, your scope should always narrow down the further you go, and what the new rules do not want or which they want to force you to, is to avoid situations where you actually broaden up the scope because you bring new issues into the proceedings. This could be new requests, new documents, but also new arguments, and we will see that. And there are these 3 levels of convergence. So the first level is what you can file at the very beginning of the appeal proceedings with your grounds of appeal or the reply. The second level of convergence is then after these initiating briefs. That's really a seizure there. After that, you're in the second level of convergence where it becomes even more difficult to get things into the proceedings, new things. And then the third level of convergence, which Arwed already referred to, is triggered by the summons or a communication of the board under Rule 102. Which is a communication setting a deadline to respond. This then triggers the final deadline. And we've selected cases for each of these levels of convergence to show you what the boards have made out of them there in the case law. The first level of convergence, so what is allowed in the grounds of appeal and the reply, is governed by Article 12 RPBA. We will not go into this into very much detail, and we refer you to our kind of basic webinar on the actual rule changes. But just to let you know that the former rules of procedure, Article 12, still read everything presented by the parties in the grounds of appeal and reply shall be taken into account. And this has now changed. Yeah? Article 12.4 says that more or less anything that has not been part of the first instance case is regarded an amendment, and you as an appellant or as a respondent need to identify those amendments and also need to provide reasons why they are only submitted in the appeal stage. So it's no longer the case that you can say that everything you file with your grounds of appeal or the reply is in the proceeding. Actually, there's not yet much case law on this first level of convergence because there are transitional provisions in place. So that's governed by Article 25 RPBA. In general, the new rules of procedure apply to all pending appeal proceedings that were pending in January 2020 or initiated afterwards. And there are only 2 exceptions. And the first concerns the first level of convergence, so regarding the grounds of appeal and the reply. Here, if you filed the grounds of appeal before entry into force of the new rules of procedure, these are excluded from the stricter requirements now of Article 12. So for grounds of appeal that were filed before 2020, still the old Article 12.4 applies. And this is then also the reason why we don't yet have so much case law on this first level of convergence, because that, of course, would need to be cases where the grounds of appeal were filed this year and which already are decided. So with a duration of the proceedings of less than 1 year, and that's still very rare. Just because we are looking at the transitional provisions here, maybe just to let you know of the second exemption that concerns the third level of convergence. And this is if you received a summons to oral proceedings or this communication before entry into force, so still in 2019, then the third level of convergence does not apply, and instead the old version of Article 13 applies. But we actually found one case where an appeal was filed this year, so in 2020, it's an examination appeal, and where the case has already been decided. So it's super quick proceedings, right? The grounds of it's an examination appeal were filed in April, preliminary opinion in June, and then oral proceedings now in November. And this is a decision which then goes into quite some detail regarding what can be filed with the grounds of appeal, so the board's interpretation of the first level of conversion. And it's interesting to read because there were several sets of auxiliary requests which were dealt with separately. There's one set of requests, 3 auxiliary requests were filed with the statement of the grounds of appeal. And here, even though they were submitted with the grounds of appeal, the board decided not to admit them into the procedure. And the reasoning the board provided is because these new requests introduce or raise new issues. They introduce a new clarity issue that leads to new objections. And this is interesting because actually we will see it in a minute when we talk about the second level of convergence. Article 12, the first level of convergence, doesn't yet actually say anything about this criterion of not raising additional new issues. That's actually something which we would have placed in the second level of convergence. Yeah, because that's mentioned in Article 13 for the second and third level of convergence. But here, actually, the board applied this criterion also to the first level of convergence. And knowing this now, looking again at the language of Article 13 for the second level of convergence, the language actually only says that the party needs to demonstrate that no new objections are raised. So meaning, in the second level of convergence, you yourself have to proactively demonstrate that no new issues are raised, but this does not prevent the boards from actually applying this criterion also to requests that are filed with the grounds of appeal. So a very, very strict approach here, in our opinion. Then another set of auxiliary requests was filed after receipt of the preliminary opinion, and also these auxiliary requests were not admitted into the proceedings. And again, here with the reasoning that they raise new issues, and the appellant then requested that the case be remitted to the first instance, but the Board of Appeal in principle said no. The requests could have been filed in the first instance and maintained in the first instance, and because this was not done, there's no right to a remittal. Yeah, so in principle, yeah, it gives you a flavor of how strict the boards are here, even in examination appeals, right? Because usually you might think that these rules are to kind of to protect the other side, yeah, from surprises and unjust behavior, but even in these ex parte appeals, so where there is no opponent, they are also applying these rules very strictly.
I'm going to give you another example, also during examination proceedings. Like Natalie said, there's much more case law on the old Article 12.4, which still applies to all grounds of appeal filed before January 1st. Now, many boards adopt a very strict interpretation of this old Article 12.4. Now, we pulled out two recent cases where you can see this, one from examination proceedings and one from opposition proceedings. Let's start with the one from examination proceedings. That case is T641 of 17. This was an ex parte case in examination proceedings, relates to packaging for cigarettes. It was heard by board 3207 with Mr. Beckedorf as a chairman. Now, during examination proceedings, the applicant here filed amended claims by way of main request. The applicant did not file any auxiliary requests during examination proceedings. Now, the examination division rejected the claims under Article 1232 and refused the application. Then on appeal, the applicant presented the original claims as main request, and again, no auxiliary requests were filed. The applicant then also requested a referral back to the first instance. Now, the board here did not admit the new main request under the old Article 12.4 with the reasoning that requests that are not maintained or were withdrawn during the first instance cannot be reintroduced on appeal. And since no further requests were pending, there was also nothing to be remitted to the first instance. So the application was refused here. The lessons learned from this is quite simple. Make sure that you always file all fallback positions, including the original claims as filed as auxiliary requests during first instance. Reintroducing claims on appeal is not a good strategy here. Now, the second example that we pulled out for you is case number 1691 of 17. This was also decided under the old rules. Now, these were inter partes proceedings before Board 3201. That is Chairman Mr. Pricolo. This is an electrical case relating to a parking assist system. Now, in the first instance, the opponent argued lack of novelty over documents D11 and D12, and lack of inventive step in view of D11 alone, D11 with D21, and D21 with D32. Now, with its grounds of appeal, the opponent changed its argumentation. It now based its novelty attack only on document D32 and its inventive step attacks on documents D32 and D21. Now, although all these documents were in the proceedings, these new attacks were not admitted into the proceedings. The board exercised its discretion under old Article 12.4 here. It argued that the mere fact that certain documents are on file does not automatically mean that you are allowed to change your lines of attack. The board stressed here that the purpose of the appeal proceedings is a judicial review of the first instance decisions, and the new attacks were not subject of the first instance decision. And the opponent here did not provide any reason for late filing these attacks only in the second instance. Now, that the lesson learned here again is that also as an opponent, you better make sure that you prepare your case from all angles, or try to prepare your case from all angles already during first instance proceedings, and include all possible attacks, even those that you consider less successful during first instance already.
Yeah, and it also shows you that you shouldn't rely too much on that your grounds of appeal or your case is still handled under the old rules of procedure, which are less strict, because actually a lot of chairmen think and legal members of the boards understand the new rules of procedure more as a codification of the existing practice. So actually they treat these grounds of appeals that were filed prior to entry into force more or less under the same standards. And this fact that document combinations, right? So here, right, the D32 in combination with D12 instead of in the first instance where D12 was used as a sole document, that this is considered a new attack, that actually we see quite often. Yeah, so that's it for the first level of convergence. The second and third level of convergence now concern submissions or requests that were filed after the grounds of appeal or the reply. These are governed by Article 13.1 RPBA 2020. This prescribes that, I mean, essentially it's the same standard as for the first level of convergence, but the level of reasoning you have to provide and the level of excuse you need to bring for filing it now even later than the grounds of appeal or the reply are higher. So in principle, you also need to explain right on your own motion why the amendment prima facie overcomes the objections raised, and that the amendment prima facie does not give rise to new objections if you file a claim request. Yeah, the first case we would like to show you in this regard is T700 of 15, which is a nice example of yeah, how you can or cannot reason if you file things late. Here at issue were several auxiliary requests that had only been filed after the grounds of appeal. Some of these had still been filed prior to the summons, so in between the grounds and the summons, but some had only been filed in response to the summons. And here, yeah, one thing that was in doubt, but some practitioners at least believed, we told you, right, there are these transitional provisions which exclude Article 13.2 for the third level of conversion. So after receipt of the summons, if your summons was issued before 2020, then this third level of convergence is excluded. But what you should not forget is that even if you file something after such a 2019 summons, the second level of convergence fully applies. So the second level of convergence is retroactive. And of course, things that you filed after the summons are also filed after the grounds of appeal. So that's why the second level of convergence fully applies. And you will see that the boards interpret the second level of convergence already extremely strictly. That's why it really doesn't help you to have received a summons in 2019. It doesn't make such a big difference whether Article 13.2 is already applicable or not, because the boards with standing case law now definitely see Article 13.1 being applicable. And here, several of the auxiliary requests were not admitted because they prima facie seem to give rise to new objections, and also others were rejected and not admitted because their late filing was not sufficiently excused. And in particular, and this is a point we will see again and again, the appellant here had reasoned that some of its new requests were a reaction to a new claim interpretation presented by the board in its preliminary opinion. But this is not accepted as an excuse if the same claim construction, for example, here was already part of the original grounds of appeal or reply. So the fact that the board picks up on an issue that was raised by one of the parties cannot be considered something new that you would be allowed to react to. And here it's an interesting case because the appellant actually tried to get the board to refer questions to the enlarged Board of Appeal. And this is something that you should follow with interest, because the boards have indicated that they do think that the enlarged Board of Appeal may play a role in shaping also what is allowed and how the right to be heard is still warranted here with the new rules of procedure. But in this case, the referral was denied. The referral asked or the questions that were proposed in principle asked whether a strict rule reading of Article 13.1 would be justified in cases where the opponent withdrew the opposition, so where the appeal was in fact then only a one-party appeal, so it was not to the detriment of the other party that something was filed late, and whether it should play a role when the rapporteur, so the member of the board responsible for the case, picked up the file, because here the appellant could show that all of its requests were filed still at a time where the rapporteur had not yet picked up the case, so it was also not to the detriment of the rapporteur, so to say, but this was not accepted as a reasoning and no referral was made. Another typical case here is T2227 of 15, which again confirms that even though the summons was issued before 1st of January 2020, all new submissions filed in response to that summons certainly fall under Article 13.1 RPBA, so the second level of convergence. And here, two minor things. It's also a partially abridged decision. We will see it later when we talk about those. Also, something not really worth mentioning, but just for completeness, there also was a new public prior use in the grounds of appeal. This was not admitted, first level of convergence. But now let's look at the new findings or the new submissions made after the grounds of appeal, so the second level of convergence. And this is just to, again, give you a flavor of how intricate these procedural arguments can be. So the first instance was about novelty over D1. And this was, of course, also part of the written submissions, novelty over D1. Then in the oral proceedings, that finding was reversed, and the appellant then, for the first time, said, well, okay, if you do not consider it to be novel over D1, then it's at least not inventive over D1. So that's a usual approach that is taken. But here the board rejected this new inventive step attack as having not been substantiated during the written proceedings, and as being late filed and inadmissible because it was raised only in the oral proceedings. So lessons learned here is definitely if you have a document which you consider novelty destroying and you only raise it for novelty, then be sure to, as an auxiliary argument, to at least write down that you intend, should the novelty attack not be followed, to also present an inventive step attack based on that document and also substantiate that inventive step attack early on. Okay, then.
One back.
Yeah.
We overlooked one.
Ah, yeah, right.
Yeah.
One positive
example.
example.
Positive example. We don't want to let you go without a positive example. Now, we also found this decision, which is more generous with regard to late filing of auxiliary requests. Now, this is decision T1480 of 16. Here, the patentee in opposition proceedings filed a new auxiliary request during oral proceedings. The auxiliary request was based on a previous auxiliary request. The only amendment being the deletion of the method claims. So the patentee here deleted all method claims and only kept the product claims in the set of claims, in the previous set of claims. Now, this was done to resolve an Article 123 objection that only applied to the method claim and not to the product claim. Now, the board decided here that the mere deletion of several claims in an auxiliary request is not an amendment of the party's case. Consequently, Articles 13.1 and also old Article 13.3 did not apply here, and the board found this auxiliary request to be admissible. Now, admittedly, this is a quite generous decision. Other boards may see this differently. It really depends on the case at issue. To be on the safe side, it's always a good idea to at least indicate in the grounds of appeal that you also intend to defend individual claim categories separately, right? That's always a good idea to do.
Okay, then let's look at the third level of convergence. Here, the wording of Article 13.2, which applies here, is really different from the previous wording. The previous provision for after summons submission said that if a new filing requires rescheduling of the proceedings or something, it should not be admitted. The new wording, Article 13.2, says that anything filed after the summons should in principle not be admitted at all, only if there are really exceptional circumstances. And there are now several decisions which give you a flavor of what is an exceptional circumstance and also many examples of what is not an exceptional circumstance. Maybe already as a heads up, I think the only clear case of an exceptional circumstance is if in the preliminary opinion really a completely new issue is raised, which by the boards themselves, which hasn't been part of the proceedings thus far. That should be something where you definitely can react to, so that your right to be heard is also warranted. But anything else will be very, very difficult. So for example, this is a case where the appellant had filed an auxiliary request after notification of the summons, argued that the auxiliary request should be admitted because the board had raised a number of new issues and the auxiliary request would be a good faith reaction to it. Here, the board said, yes, okay, we raised new clarity issues in that case. It was an application examination appeal ex parte. So there were new issues raised, so they admitted this auxiliary request too. But then in the oral proceedings, they decided that it did not comply with the requirements of the EPC, so clarity and added matter objection. And then the appellant wanted to file an additional auxiliary request in reaction to that finding in the oral proceedings, but this was then no longer allowed. So that shows you in a way that you might only have one shot, because the board here refused to allow a back and forth or a filing of further and further requests, always if, of course, a new issue is raised in the oral proceedings then, for example, but this does not give you a right always to file new requests. So you should better make sure that the auxiliary request that you can then get into the proceedings also really holds. This is another interesting case just to show you how things can go. Here it's about the admission of a document, and you see how much these procedural issues take up also in the written decision here. D17 was a document that was filed with the grounds of appeal, and the admissibility was first contested between the parties, and that's why in the oral proceedings, the admissibility of the document was discussed. But then the respondent suddenly did no longer object to the admissibility of document D17 and wanted to have it in the proceedings, because apparently there was something in the document that helped his case. And the appellant then reacted by withdrawing the document. So withdrawing its request to admit the document. And then respondent in the oral hearing said, well, now I submit document D17 and I request that it be admitted into the proceedings. And this the board considered to be an amendment of respondent's case, because so far respondent had always objected to this document. Now he wanted the document in, but in the end they let document D17 into the proceeding. I think it's a very logic case in a way, because of course it did not increase the complexity because it had already been discussed. But still, it's interesting. It's also interesting to read because here, kind of in a obiter dicta maybe style, the Board of Appeal also put down some considerations, because this was a case where Article 13.2, so the third level of convergence, did not yet apply because the summons was before January 2020. But here the board explicitly wrote that this does not preclude them from actually applying the principles set out in Article 13.2. That again goes in this direction that many chairmen see these new rules of procedure only as a codification of the existing case law. So you should not be relying on if the transitional provisions apply to your case, that they will actually also really be applied to your case. I think this is a final example of Board 3301. So a pharma case, it's an interesting decision to read for pharma practitioners, because it's about sufficiency of disclosure and how much data an application should contain in order to support such a broad medical use claim as here, an antibody for preventing and or treating vasculitis in general. There were doubts raised in the procedure, also in the application, that the antibody could actually really treat all types of vasculitis. There were less doubts regarding certain subset, but the claim was broad. And in the first instance, the opposition division had rejected the opposition and these sufficiency attacks. But now on the appeal, the board found that the patent only insufficiently disclosed the entire scope of the claim. And then here the patentee reacted by then on appeal in the oral proceedings to file a request where the vasculitis was then limited to the two particular types of vasculitis that were also exemplified in the application. And this auxiliary request, although one could think that it's a relatively straightforward, simple reaction, which could have been foreseen also by the other party, was not admitted. Because the sufficiency objection had been raised all along already with the grounds of appeal. So the latest with the response to that grounds of appeal, the patentee should have filed this fallback position, and the patent was revoked. So this just shows you how difficult it can be for patentees that do not file all of their fallback positions, even if they don't consider them necessary, because here the first instance decision was positive for the patentee. You cannot rely on that and hold back auxiliary requests.
Yeah, this is another interesting case here where the board in opposition proceedings changed its preliminary opinion. There was a first summons here in that case where the preliminary opinion was positive on inventive step. Then these oral proceedings were postponed due to the corona pandemic. And the board then issued a second preliminary opinion where it took a different view on inventive step. Here it found that the invention lacks an inventive step. Now, the patentee then reacted to the preliminary opinion by filing new auxiliary requests, and the board refused these new auxiliary requests under new Article 13.2, arguing that a change in the preliminary opinion from favorable to unfavorable does not justify the filing of new requests. There is one exception to this, I guess, and we recently had a case like that when the board comes up with reasonings that are new in the proceedings with entirely new aspects. Then, of course, you have the possibility to react to that, but not if these are simply facts that were and arguments that were already presented by the other party, and the board simply changed its preliminary opinion. In practice, this happens quite often. We recently had a case where the board changed its preliminary opinion at the beginning of oral proceedings. We then asked for an interruption and found that it was not necessary to change our defense strategy. But this is what happens in practice, what does happen in practice sometimes. Yeah.
Yeah, I think in the interest of time, we can keep this one short, probably.
Yeah, just I mean, the boards now have, under the new rules of procedure, now have the possibility to issue abridged decisions. We looked into the case law, what we could find in this regard. There are two options here for the boards. If both parties give consent to an abridged decision, they can do this. Now, we couldn't find any decision like under Article 15.7. Now, we did find a number of decisions where under Article 15.8, where the boards referred to the first instance decision. This particularly applies in cases where, and to issues where nothing new happened during appeal. Then the boards now quite often refer to the first instance decision rather than copy and paste. They just refer to it, which I think makes complete sense. We put down these decisions there for you to take a look at. I think it's what the last decision is only 4 pages, so these decisions are quite short.
Yeah, and maybe as a last point, let's talk about remittal. Here also the wording of Article 11, which governs the remittal, changed considerably. In the previous version of the Rules of Procedure, Article 11 said a board shall remit a case to the Department of First Instance if fundamental deficiencies are apparent, unless special reasons present themselves. Now it's exactly the other way around. The Article 11 now says the board shall not remit a case to the Department of First Instance unless special reasons present themselves. And here also we've prepared a short survey just to get your views on this. Regarding this reversal in the language. Do you expect that this new Article 11 leads now to less remittals, right? Because it says the board shall not remit a case to the Department of First Instance unless special reasons present themselves. So at least I have to say, when I first read the draft new rules, I thought this is the case, shall not remit a case to the Department of First Instance. So we were particularly curious to now review the cases that are decided. And indeed, I see that that you also see it similarly. So the majority expects less remittals, and there are 40% of you say no, I do not expect any changes, but at least there's nobody who expects more remittals. But the practice is actually that we have the feeling that it's either certainly no change, or that even the boards still favor remitting. And the reason for that is that next to Article 11 that was changed, also Article 12, the basis of the appeal proceedings, were changed. The appeal proceedings shall be limited to the subject matter of the first instance decision. And then also Article 12.2, in view of the primary object, to review the decision under appeal in a judicial manner. So in cases where the first instance did not decide on something, the cases that we will now see show, and that's also statistically the case, that the boards are remitting. Also, I think because it's also a way for them to clear their backlog in a fast manner. So this here, for example, is a typical case. That similar cases we've also experienced throughout this year. That's really like a common theme. First instance decision decided on novelty and sufficiency, and then killed the patent on that ground, but inventive step was not discussed. In the appeal proceedings, appellant managed to reverse the decision, but then the case is remitted to the first instance to discuss inventive step. And in a very similar way here, another two cases where, again in 275 of 15, first instance decision dealt with novelty, but not inventive step. And then again, the case was remitted to the first instance to discuss inventive step. T1077 of 17, case where the first instance decided only on sufficiency of disclosure, but then again did not go into novelty inventive step. Board reversed that decision and again remitted to the first instance. And there's a number of cases which dealt with this in a very similar way. So those of us who had hoped that there would be less remittals are a bit disappointed here, because nothing has changed, or the boards are even now use Article 12, 1 and 2 actually to remit even more strongly to the first instance. I guess the only way to change this is if the first instance would actually decide on all issues, or at least in way of obiter dicta indicate their opinion also on the other matters. And also it depends on the parties who, of course, by presenting arguments on subjects that were not decided on, also help a board to actually then deal with these matters. One case here where no remittal took place is a case where it's about the auxiliary request, because here in principle, if the first instance decision already killed the main request, killed the patent on the main request, upheld the patent based on the main request, then of course the auxiliary requests were never dealt with in the first instance. And that's something that's very common. And here in principle, you could also say that a hardliner might say that, well, then if you deal then with auxiliary request 1 as a board, you're not judicially reviewing the first instance decision, because the first instance decision is silent on auxiliary request 1. But luckily, at least this board here did not see it in this way, and then decided also on auxiliary requests which were not subject matter of the first instance decision. But you see here that there's some leeway for the parties to request remittal and to provide reasons why, in case law now, why the board should remit if you're interested in prolonging the proceedings. On the other hand, if you are not interested in prolonging the proceedings and want a decision on all grounds, you should proactively act in that way by presenting the entire case, forcing the Board of Appeal to look at all these issues, and also presenting reasons why they should not remit, because it's not the default that they are not remitting. Yeah, I think we are a bit short on time, but let's finish up with those two decisions.
I think these will be quite quick. Now, one sure ground for remittal is if there is a substantial procedural violation. And we found two decisions that show this, recent decisions. Now, in the first one, T1879 of 17, the opposition division did not allow the patentee to submit any further auxiliary requests. So they really decided not to admit an auxiliary request into the proceedings without first looking at it. Now, this the board here found that this was a violation of the right to be heard and remitted the case to the first instance. Now, in a second case, T2538 of 18, the opposition really came up with a particular formulation of the objective technical problem for the very first time in the written decision. The parties did not talk about this particular formulation during oral proceedings, and neither party had the opportunity to comment on it. The board found that this was a breach of the right to be heard, and also in this case remitted the case back to the first instance. So these cases relate quite clear procedural violations.
Yeah, and I think at least we've heard from a couple of chairmen that this is also a reason for acceleration. So on their own, if the registrar sees that a procedural violation is provided here as reasons in the appeal, they try to pull that upfront in their list of cases and to remit that soon, so that no time is lost. But here again, as a party, you can influence that by either really pointing that out really in fat and bold in your appeal grounds so that it's immediately apparent, or maybe hiding it more in the text of your grounds of appeal if you're not interested in a fast procedure here. Yeah, and then let's maybe wrap it up. So I think the recommendations are relatively clear, as we also put down in our basic webinar on the rule changes. I think the first decisions that we saw now in 2020 have made very clear that the boards very strictly apply the new procedural rules, so that you should really file all relevant submissions, all auxiliary requests, all document combinations, all arguments you might want to rely on later on as early as possible. And this means in the first instance, and definitely with your grounds of appeal, and also with the reply to the grounds of appeal. I think that's also a very, very important brief, which in the past might not have played such a big role, but now really plays a huge role, because as a respondent, you cannot rely on the positive first instance decision. As soon as you receive the grounds of appeal, you need to react to them. If the board surprisingly picks up on one of these grounds, it's not for you a justification later on to file new facts, arguments, requests, and so forth, that you should do with your reply.
And for the auxiliary requests, make sure that you not only file your auxiliary request, but also explain and the disclosure for all auxiliary requests, and also present all arguments and objections for the auxiliary requests as early on as possible, because otherwise you risk that these will not be admitted, right?
Yeah. Yeah, and maybe now it's 5 minutes past the hour. We still have 2 slides prepared for you, where we wanted to show you a little bit about our views on the new issue with video proceedings before the boards of appeal. But maybe let's break here and just see if maybe some of you have very pressing questions here now on the actual rule changes and the case law. So if you have those, please raise your hand or put them into the Q&A tool. Otherwise, I would suggest we finish those 2 slides and then open up the discussion afterward. Yeah, but right now I don't see any specific questions, and also no raised hands. So I would say let's then quickly just spend maybe 1 or 2 more minutes on this very pertinent and current topic, video proceedings and the right to be heard.
Yeah. Yeah, as many of you may be aware of, there is a new proposed Article 15A, just that was recently proposed. There's currently a consultation on this new proposed Article 15A in progress, really what Article 15A proposes is that the boards can schedule oral proceedings as a video conference, also without the consent of the parties, right? And not only that, this is also not limited to the current pandemic, where it might make sense in many cases to hold video conferences, but it can, the regulations are set out that they is not limited to the pandemic situation, but can also be carried on later on.
Yeah. Yeah, and maybe also here we would be very interested, yeah, to hear your views on this. So what your opinion is on video hearings before the EPO? Yeah, maybe just hit your answers. You have the choice between maybe you're generally against video hearings and think oral proceedings should take place in person whenever possible, or you are more moderate view that video hearings can make sense, but they should always require the consent of the parties. Maybe you're of the opinion, fourth option, that Article 15A here is perfectly correct the way it's worded, so the chairman should have the power to impose video hearings also against the will of the parties. Or maybe you're of the opinion that in general the EPO should completely switch to video proceedings. So that's very interesting to see hear your answers. Yeah, still some undecided. I still wait some more seconds. I'm seeing answers are coming in, so it's not an easy question to answer. But I will close the poll now and share the result with you. Yes, and that's actually quite balanced approach, but it's interesting to see that yeah, only one of you said that generally against video hearings and that all oral proceedings should take place in person. I think that's also something we've experienced now in the pandemic. I think if we would have asked this poll before the pandemic, there would have been much more, which would have said never oral proceedings per video conference, but also we have made good experiences with it in certain cases, but the majority of you is of the opinion that video hearings can make sense, but they should only take place if all parties agree to them. But interestingly, there's also around 40% of you that say that either the Boards of Appeal should be able to order video hearings. That's of course, if you say, well, there will always be one party that disagrees, and this then maybe also now in the pandemic postpones these hearings indefinitely. Yeah, so thank you for your participation there. And maybe the final slide concerns hybrid video proceedings, and that's something that's also hotly debated, and that was also part of this user consultation. Hybrid means that part of the parties, so either one party or part of that party, so maybe one representative is present in person at the oral hearing, at the premise of the EPO, and other parties or parts of parties are present only remotely. And there's a lot of debate on whether that is justified and so forth. But what's certainly something that the community would like very much, if it were, for example, possible for the client or the party itself to only have its representative at the EPO, but him or herself to be able to join remotely. That, of course, especially makes sense in cases where international travel also would be required. And here, there's a mixed approach. So we found one case, the decision is not yet written, so it's that's why I provide the EP number here. That was a case where, I mean, in the pandemic, the board allowed one party to stream the proceedings via Skype to parts of their in-house team that were unable to travel due to the pandemic. So that was something on very short notice. I think 2 or 3 days before the hearing, it was clear that part of the team could not travel. And then the chairman in that instance decided, yes, I allow the representative to transmit the hearing. In a different case now, which has received a lot of attention, but which you should read carefully, such a request was denied. So here also a representative wanted to share the proceedings via Skype with his client, parts of the in-house team of his client, and this was then rejected, the request. But you have to look at the details here. The other side, the respondent had objected to a video conference. And also here the board paid or focused in particular on the fact that this transmission was not under its own control, and that right now, it says, the facilities of the EPO do not yet allow for the boards to themselves conduct such hybrid proceedings. But it sounds a bit as if, in principle, if the technical facilities were present, that that might not be objected to. And also it's unclear what is in a case where both parties, maybe both have an interest to transmit the proceedings to their in-house teams. In such a case, it might also be worth a try. So that's something to keep an eye on. Yeah.
It also, the boards appear to take very different positions on this, right? One board takes another position than another board, right?
Yeah, so here it's definitely recommended to get in contact with your board prior to the oral proceedings to indicate what actually your preference would be, and to see how the board's view is on these matters. Yeah, I think with this we can close. Yeah, so we thank you very much for your attention. Those of you who are now dialing off, we will also wish you a very Merry Christmas. And also just a brief reminder, if you like this webinar and you would like to receive information on future webinars, please, you can register for our event mailing list, or just respond to the email you have received and we will add you there. But I also see now that we have the first question here, which we will deal with. But while I answer to that, those of you who would like to enter into a discussion with us, also face-to-face, please raise your hand via the raise your hand function, and Christiane will promote you to discussion participants so that we can discuss with you. Yes, but the question we have regards the public in these video proceedings. So how is that, the right of public proceedings governed? And that's very clear. So there are two alternatives here. Either the Boards of Appeal transmit the video hearing into a separate hearing room at the EPO Boards of Appeal in Haar. Yeah, so you have to travel there and then get seated into a separate room where you see on screen the video hearing, or as an alternative, some boards also send out links to the video hearing where selected members of the public, if they register in advance, can attend the hearing. But that's definitely something you should get into contact with the front desk of the EPO Boards of Appeal to let them know in advance that you're planning to attend.
Yeah, also because of seat capacity right now, right?
Yeah.
During the pandemic, they run out of seats very quickly, so it's a good idea to call in advance.
Yeah, so enjoy the rest of your day and have a Merry Christmas also, and see you hopefully next year again. Yeah, bye-bye.
Thank you, bye-bye.